Good morning, everybody. It's time for the inquiry to resume. I've just a few things to mention at the outset of today. Firstly, on documents, just a very quick update. We've received a note from National Highways concerning areas of the Orderland in which they have an interest, and that's essentially confirming the evidence that the inquiry heard yesterday from Mr. Franklin. So we're happy to accept that as an inquiry document. We've also now received notice of withdrawal from Cadent Gas. That also goes in as an inquiry document. And the third one to mention is we've received the list that we requested from the district councils of the relevant development plan policies. I don't think there's any disagreement about those policies, but that will go on the co-document website. Just a very quick word about closing submissions, which we'll be expecting to hear at the end of next week. We're conscious that there are parties involved to whom this may be an unfamiliar process. So just to make it clear that in accordance with Rule 1813, we would expect closing submissions to be handed up in writing. We would also welcome electronic copies in Word format as well. Just so that everybody is aware who we're expecting to hear closing submissions from. The applicant itself, of course, will make closing submissions. The applicant will appear last on the 21st of November. The day before, we're expecting to hear closing submissions on behalf of the Mayor of the Combined Authority, Coat and Orchard and Houston Crest Properties jointly, the J&WR Sadler, Cambridge Past, Present and Future with Coat and Parish Council, and the two district councils combined. The other thing I have to mention is that very late yesterday, the programme officer received an email from a Miss Marchant, which I think has been copied to the applicant, indicating very late in the day that Miss Marchant has some thoughts, some representations on transport modelling. She does say, which she'd like to be considered within the scope of the inquiry, she does say that she doesn't consider it necessary to appear, and that she then refers to the possibility of a brief note, but says that the email itself may well contain the points that she wants to put before us. It's certainly not our intention at this late stage to encourage an additional appearance. Having regard to rules 18.4 and 18.11, it's our, well, perhaps before I go on to say what our view is, Mr. Cameron, have you?
So we've seen it.
Yes.
We understand that that Jan Merchant, I think is the name, made a Freedom of Information request.
That's right, yes.
And that is due to be responded to shortly.
Yes.
And so the way that we were planning to deal with it is to respond to the public authority to whom the request has been made will respond to the Freedom of Information request. And we've asked to see, when it's available, that response. And it may be that the response to the Freedom of Information request is sufficient to answer the point, and that the whole process takes place in that context rather than in the inquiry context. But I'll wait to see, sir, what you're about to say in relation to the rules, and I'm just about to get them in front of me.
Well, she has made requests in parallel, Mr. Cameron. She's there's a clearly request for the inquiry to consider things as well as the freedom of information request. I don't think her circumstances is specifically covered by the wording of the rules, but having regard to the intention of the rules, as I said, we don't intend to invite an appearance, particularly she doesn't consider that to be particularly necessary, but we're minded to accept the email rather than anything else as a written representation, with the opportunity clearly for yourself and Mr Henderson to deal with written reps week on Friday.
Thank you, sir. Well, we will consider it and consider the appropriate response.
Okay. I've got nothing else to mention at the moment. So, Mr Cameron, have you?
Yes, sir. Number of issues arose yesterday.
Yes.
Conditions. I said we would submit a revised list, including the condition 34 today, and I hope that that has now been done. So that's the first point.
Hopefully it's on its way. Mrs Vincent's shaking her head at the moment. Right.
Well, good. Next point, you requested a hard copy of the highway boundary map 2989, and I'm
yesterday.
told that you've got it.
Yes.
Next point, sir, is on you raised a point about the representation, the objection made by the Jenkins family in relation
Yes.
to ownership of two plots.
Yes.
And they are plots 4041A and 4041B.
Yes, that's right.
The interest is referred to in the book of reference.
Yes.
So we've got that as CD 113. And if you go to page 32 in CD 113, you'll see the interests noted. What the Jenkins family said in their objection was that they were not the owners of those plots.
That's right.
But if you go to page 32, you'll see that they're not. I'll just let you get that, sir. So it's CD 113, page 32. Oh, sorry, 31. It's 4041A and 4041B. Thank you. For some reason, my system seems to have found an additional page.
Nice.
And so you'll see that the interest noted is under the heading, the column tenants and occupiers.
Yes.
And they're all so Martin John Jenkins,
Yeah.
in respect of a transfer dated the 31st of March 2005, and the same with the other members of the
Yes,
Jenkins
I see
family. So they're not identified as being the owner, but having a legal interest under a transfer. And so this was picked up in the applicant's statement of case. So that's core document 2301, and it's paragraph 14.6.6, and that, my numbering is page 113, and that is the number at the bottom of the page, so hopefully it's the same. And there it explains that plots 4-041A and B are within a larger National Highways registered title in which the Jenkins family is listed as having an interest. The applicant has followed the required procedure to identify and notify all parties with potential interests in these plots of land, listing these parties in the book of reference does not confer ownership of the land. So that is the answer to the point, sir, that you raised, and that's all in the documents. You have to hunt around a bit for it, but it's there.
Okay, thank you.
And just while we're on the book of reference, I asked Mr. Franklin about the identification of the owner of the land adjacent to Clare Hall, including plot 16178, which is on page probably 79 in yours. And when it refers to the master or keeper and fellows and scholars of the College of the Blessed Virgin Mary, St. John the Evangelist and the Glorious Virgin St. Radegund, that is Jesus College, Cambridge. So it doesn't say Jesus College, but that's their official name. So that's the answer to that mystery. So I think that's all from me, but you also asked, or Mr. Underwood asked, about the Water Framework Directive, and Mr. Henderson is going to answer on that.
Yes, just want to come back before we give you more paperwork. I want to see if I can deal with it in 2 minutes now, such that you don't feel it necessary to receive anything further from us. You've already identified Appendix TR 13.2, which is CD 111 13.03. That is part of the environmental statement, and it's the WFD screening and scope and assessment. That identifies two potential surface water bodies of concern, the Bin Brook and Old West River, and it concludes, and I think you've identified this, that essentially there is agreement between the Environment Agency and the applicant that at the detailed design stage it is highly likely and therefore sufficiently confident that any adverse impact can be avoided such that there's compliance with Article 4 of the directive. And you've identified that reference in paragraph 4.1.1 there. That, I should say, is also in the Statement of Common Ground, if I can give you the reference to that, 2977, page 5, row 5, and it's the entry for the 11th of April 2023. So that's what's in the material before you. You asked about securing that. 2 points to say there, which hopefully will deal with the concern, but I want to flag them now. The first is condition 19, which you have is, if you're using the most recent list, CD 2912. Condition 19 specifically deals with the Bin Brook Bridge and any other bridges or structures, including embankments and the like, which would be control over the detailed design of those elements. That's the first thing to say. The second thing to say, and this is identified both in the Technical Appendix TR 13.2 and also in the Statement of Common Ground with the reference that I gave you to the 11th of April 2023, is the Environment Agency anticipate, and we don't dispute, that we would provide satisfaction to them again on this issue as part of the FRAP process. Of course, a separate statutory process to which the Gateshead principle would apply. And so we say you've got control on the detailed design under that condition 19, and with the combination of the FRAP and the statutory framework around that, plus the clear indication from the Environment Agency that they have no concerns consistent with our own technical evidence, that is a matter that you can leave over lawfully to that FRAP process, and for the purposes of Secretary of State's decision now, having regard to both of those mechanisms, the conclusion would be that there is compliance with Article 4.1 of the Water Framework Directive. So that is the answer on the material before you. If that's not enough, if you want a bit more, please say, I don't say do so now, but maybe at lunchtime or after lunch, please just flag it to us and we will of course provide something. But I'm conscious that we're nearing the end. I'm conscious you don't want more documents in writing, and I'm trying to avoid that if you're happy with what I've told you this morning. If you're not, though, we obviously will deal with it, but hopefully this is a more efficient way.
So just for the avoidance of doubt, I mean, your position is that that you're saying that the combination of, through the order and deemed planning permission process, condition 9,
19, sir.
19, yes, so that's 19, should give the Secretary of State confidence that's going to be
Plus the FRAP,
and the separate FRAP
Yeah.
process,
which is the Gateshead principle.
Obviously, that is separate to the order.
Yes.
The order process, and
Yes.
the Secretary of State will need to take a view on the order. But I'm just conscious that I think the issue I just wanted to make sure I understood your position on was the fact that the Environment Agency have obviously they haven't reached a conclusion on whether the scheme is actually WFD compliant. They've obviously given an indication. I think they've used words like highly likely, if I remember right, or they obviously have confidence that it's going to be Water Framework Directive regulation compliant. So I just want to make sure that from your position, you're confident that those mechanisms gives the Secretary of State, should the Secretary of State decide to make the order, that they will have discharged their statutory duty under the regs.
Well, it's not under the regs, to be clear.
Sorry.
The duty under the regs is just to have regard to the management plan,
yeah.
but under the directive, yes, without troubling you on what the state of the directive might be post-Brexit, but just take it totally at face value. The answer to that is yes, and a conclusion of highly likely agreed with the EA is more than enough, even on a precautionary basis, for you to get to that point. If you want, we can put in, there's a case called Immingham very recently, dealing with a similar issue of leaving over matters in a DCO context, but equally applicable to this infrastructure scheme, to a separate statutory process. High Court reaffirming the application of the Gateshead principle there. If you want that in as part of our closing, we can give that to you. That's absolutely fine. But to answer your question, we think you've got everything you need. But please let us know later today if you disagree, and we'll do something further.
Yeah, in terms of what you told me today, and you've given reference to documents that are already within the inquiry, I think it's very clear what your position is. So I don't think I need any further statement. Whilst I don't really want any other things, I think it may be helpful just to have those two authorities. I'm not expecting there to be any great discussion about them, but just so that those two authorities are within the
Yes, of course.
the documents. I'll just check. Yeah, I think that, yeah.
That's absolutely fine.
It just means that if, and I'm not saying we'll need to, but if in any recommendation we need to make reference to them, it's clear that those authorities are part of the inquiry documents. So.
Yes.
So that'll be both Gateshead and Immingham.
Immingham, correct. Yes.
Thank you. Yeah, but yeah. So thank you for that explanation. It's been very helpful.
No problem.
I don't think there was anybody else raising any issues about it. This was just an inspector thing. So I'll just see if anybody's got any comments. Mr. Parker's busy on something else there. So. Yeah, thank you.
Okay, thank you. Mr. Parker, do you have anything to raise?
No, thank you. No.
Chair, there's nothing from anybody else. In that case, Mr. Cameron, is it going to be yourself?
It is.
I think it will be your last witness, Mr. Cameron.
It will, which is highlight from the I'll call Stephen Sensible.
Thank you.
So, are you Stephen Sensible?
I am.
And you have provided a note to the inquiry, which we have got as core document 2962, supplementary note. And in that note, at section 1, sorry, I'll turn this on. At section 1, you have, so we all switched on so everybody can hear us. Set out your qualifications and experience. You are a member of the Royal Town Planning Institute.
I am, yes.
And until April this year, you were an equity partner at Carter Jonas and the firm's head of planning and development for the South. And on the 1st of May, you became a consultant to that firm. Is that all correct?
That's all correct, yes.
And you set out your extensive experience and the diverse list of clients who you've acted for, including the University of Oxford, a number of Oxford colleges, the Defence Infrastructure Organisation, Berkeley Strategic, St Modwyn Developments, and Advanced Research Clusters, amongst others.
Yes.
Thank you. Now, just so that the inquiry knows where we're going, I'm going to start off with some questions about planning policy. We're going to deal with adopted development plan. We're then going to look at the emerging local plan strategy, national policy. We're then going to go on to some planning matters, heritage balance, green belt, policy in relation to veteran trees, not the detail of arboriculture, policy in relation to flood risk, policy in relation to open space, conditions insofar as we need to, but there is a separate condition session. We'll then go back to look compendiously but not in detail at the Secretary of State's main issues. Then we'll deal with the planning balance, and then we'll have a short diversion onto the Section 19 Acquisition of Land Act application. So quite a lot to get through. So can we start please on local plan, and can we start on the South Cambridge District Council local plan, core document 602, please?
I have that.
And I'd like to start, if we can, page 35. We're going to deal with strategy, and there is a policy S2 objectives of the plan, PDF 34, paper copy 22, and then there is a policy S6 which has the strategic allocations.
Mm-hmm.
Are they relevant when determining this application?
Yes, they are. I mean, if we look at policy S2 and start with criterion A, part of the vision for the local plan is to support economic growth by supporting South Cambridge's position as a world leader in research and technology-based industries, and I think we'll keep coming back to that about the importance of this area in terms of not just the local policy but regional and national considerations too. And then if we look specifically at point F, one of the objectives again is to maximise potential for journeys to be undertaken by sustainable modes of transport, including walking, cycling, bus and train. So again, very pertinent to the matter that is before this inquiry.
And if we go to S6, which we find on PDF page 40, we have the development strategy, and we've got at three new strategic scale allocations. Does this scheme affect any of those allocations?
Yes, it does. I mean, the first thing to say there is that the three sites identified, well, the first two of them certainly are envisaged to extend beyond the period of this local plan, 2031. But then we've got Bourne Airfield and Cambourne specifically referenced, which and we'll go on to other policies where this comes to the fore. They are to a greater or lesser extent dependent upon the C2C, and we'll come on later to the emerging policy and how that fits with the current development plan policy.
Right, let's go to Bourne Airfield, and we've looked at this before in the inquiry, but if you go to page 84 in the PDF, we've got policy SS7, and I think if we go straight to page 86, SS7, 8, is this scheme, is the policy engaged, and is the scheme compliant or non-compliant?
The policy is definitely engaged. It says at 8, the new village will be founded on a comprehensive movement network for the whole village that connects key locations, including the village centre and schools, to encourage the use of sustainable modes of transport. Then there's further detail around what that means in terms of public transport provision and reference to emphasis on journeys by bus and the creation of a new, this is at 3, A little 3, provision of a high quality bus priority measures or busway on or parallel to the A1303 between its junction with the A428 and Queen's Road, Cambridge. So the existing, the current local plan clearly envisages a busway or similar as proposed by the scheme in front of this inquiry.
And Bourne Airfield, while we're still on that, let's turn to the decision notice on the Bourne Airfield Outline Planning Commission, core document 406, and we've looked at this, and we have condition 13 on page 13.
I've got an old school hard copy here, so.
Right. Well, I think it's page 13 of 41.
I've got it anyway. Yeah.
And
Can you give me the reference again?
core document 406, page 13, condition 13. And the inquiry is very familiar with this condition. Mr. Sensical, you have, save where you've indicated in your note, adopted the evidence of Mr. Ralph Lewis, and in his rebuttal, if you've got that,
I have.
at 4.2.6, page 7 in the paper copy.
Yes.
And he says it's right to say that the law provides a procedure which would allow a different condition to be substituted when granting a further planning permission. He's referring to section 73. But he says, it is my view that no such planning permission is likely to be granted. And Stephen Kelly has already given evidence on this, but what's your view?
Well, my view, based on what Stephen Kelly said and having regard to Mr. Lewis's evidence and the evidence we heard on previous days, is that the background to this policy and this particular condition is such that it would seem to me politically very unlikely that members would agree to a variation of the condition or its removal until such time as the busway was in play.
Thank you. Can we go on to Cambourne West? And so we go back to the local plan, core document 602, and we're going to go to page 90, and we've got policy SS8. We note that although the allocation was for 1,200 dwellings by 2031, a planning permission was granted for a greater number, 2350. That's noted in the reason justification to the plan.
Yep.
At 365 on page 95. But can we just go to SS812 and again, how does this application for the Transport and Works Act order interact with this policy?
Again, it does interact with the policy. If we look at 12 under the subheading access, development will provide for additional travel demands generated. Development will need to address, but is not limited to, the following. And then there are a number of references there to the need for sustainable transport solutions to facilitate the development of this site.
So,
including at B, high quality segregated bus priority measures.
and so how is the proposal for the Transport and Works Act order and the request that planning permission be deemed to be granted, is that consistent or inconsistent with the strategic approach in the local plan?
It is consistent with the strategic approach in the current adopted local plan.
And how could the strategic approach be delivered without a scheme such as that proposed?
I'm not clear that it can. I've seen nothing before this inquiry to suggest that there is a way in which it could be delivered without this proposal being brought forward.
Thank you. That's on strategy and those allocations in the local plan. But before we leave their local plan and dealing it all together, can we just go to page 129, please, which is completely different point, but this is policy NH5, which is dealing with sites of biodiversity or geological importance. So if one has a county wildlife site and a proposal has an adverse impact on a county wildlife site, such as at Coton Orchard, how is that issue to be approached in accordance with the local plan policy?
Well, first point I would make, and I may have missed it, but I don't think so, but I don't believe that the Coton Orchard site does appear on the proposals.
Better shut the door. We'll just shut the door for the moment.
Yeah, he did suggest he was going to stop.
There we go.
Yeah, sorry. I'm just saying the first point I would make is that I've looked and looked, but I can't find the Coton Orchard site on the proposals map for this local plan. I just make that point. I mean, I accept that it is a county wildlife site, but it's not on the proposals map.
Let's assume it is.
I just make that point. And it says there at 1, proposed development likely to have an adverse effect on land within or adjoining a site of biodiversity or geological importance, as shown on the policies map, will not normally be permitted. Exceptions will only be made where the benefits of the development clearly outweigh any adverse impact. Now, there's been debate via other witnesses as to whether or not there is an adverse impact and whether that's being mitigated. But, I mean, the short point for me is that the benefits of this scheme that are manifest in documents across the evidence. It's not just a local benefit. Well, there's as we've just discussed, there's the issue around delivering the currently adopted local plan. There are wider issues around the case for Cambridge and further growth. We've now got the emerging local plan. It seems very clear to me that the benefits of this scheme do clearly outweigh any adverse impact, if there is an adverse impact on Coton Orchard.
Thank you.
So to that extent, we do not contravene the policy.
Can we then go on to, and we're only not covering every policy, just dealing with highlights, so to speak. Can we go to the Cambridge local plan, which is core document 601, and we're going to go in that to page 80 in the PDF, which is Policy 19, West Cambridge Area of Major Change. And we have that, and we have in the reason justification at 374 on page 83, if you've got the paper copy at 76, but PDF 83, key to the success of the new proposals will be an integrated and accessible, sustainable public transport strategy which considers all modes of travel, including public transport, to ensure that development has an acceptable impact on the surrounding transport network. So again, how does the scheme, that's the Transport and Works Act order application scheme, interact with this policy? Does it support it, conflict with it? How does it?
It supports it. It's as at the same position as we're in with the housing sites that we've already referred to. It's quite clear that in adopting this policy back in 2018 after the examination, that key to the success insofar as the council is concerned of this employment site and its strategy generally is the provision of integrated and accessible sustainable public transport, and that is precisely what this scheme is.
Thank you. Can we now go on to the emerging local plan strategy? And before we go to the detail of it, can we just address the question of weight to this document? And starting point for this, if you've got the MPPF, we have it at core document 8.1, the framework, and para 49, please. And in your note, you refer to weight at 5.8. We heard from Mr. Kelly that it's yet to be endorsed by the council cabinets. So what weight do you give to this emerging policy?
We have to give it limited weight. But I think, as I say in my evidence, there's a bigger picture issue here, which goes back to the long-standing strategy of the councils in seeking to bring forward sustainable modes of transport to facilitate ongoing growth, because we do have an emerging local plan that does flow from and build on the existing local plans. So there is that consistency of approach, and that has weight in my view. But I accept that on a strict test, the new plan, given that it's not yet been ratified by Cabinet, is clearly of limited weight in the context of paragraph 49.
But as you say in your supplementary note, you say limited weight. That's page 7, 5.8. But if we go to 518 on page 9,
yeah,
you refer there to a 518, a synergy and consistency between emerging policies and the C2C.
Yeah, that's the point I'm making. That we have councils here that have, if you like, to use the hackneyed phrase, been on a journey for some time in terms of facilitating growth and as to where that growth will take place. We've now got the potential for that growth to be accelerated through the support from government, in the case for Cambridge and other initiatives. So there is this consistency of approach, which, to my mind, gives more weight to the emerging policy in that it is consistent with that long-running objective, or those long-running objectives of these councils.
Well, let's just turn to the documents if we can, please. And so we need to go to core document 29-71-2, and we'll go to the overall strategy as referred to by Mr. Kelly. And first of all, I want to just deal with Greenbelt and how this emerging policy deals with Greenbelt. And can we go to page 70, please?
Sorry, Mr. Cameron, could you give me the reference of the...
Yes, it's 29-71-2.
Thank you.
And it's page 70 in the PDF, and it's page 70 in the paper copy. And it's paragraph 2.65. So have the councils joint plan, have they approached Greenbelt and exceptional circumstances, the overall picture on Greenbelt?
They've carried out a Greenbelt assessment, and they've come to the view that, save for one site, 2 sites, sorry, that where there will be limited Greenbelt release, the main thrust of new development, or the body of new development, will be beyond the Greenbelt. So they are looking to preserve the Greenbelt around Cambridge and to leapfrog out to the new settlements on the or beyond the Greenbelt, where development is occurring and where they are looking to consolidate and accelerate that growth.
And if you...
Can I just, sorry,
yes.
Mr. Cameron, to butt in, I must also correct, I said in my note that there were no Greenbelt releases, and yes, there are, and I accept that there's an error on my part.
And you've just identified the two.
Yes.
Thank you. And if the strategy is to, I think you used the word leapfrog, beyond the Greenbelt, apart from those two where the council take the view that exceptional circumstances do exist.
Yep.
How does that impact upon the transport strategy for the local plan?
Well, given that the councils have identified issues of congestion, in terms of getting into Cambridge from these settlements beyond the Greenbelt, I think it further emphasises the importance of schemes such as C2C to facilitate that growth.
And if we go to core document 29-71-4, which is the next part of the local plan, and we're going to go to, if you've got it in the paper copy, it's page 256, but it's PDF 3 in our core document. So 29-71-4, so.
I've got that.
And there should be a figure 75.
Yep.
So we can see Greenbelt and proposed site allocations, and we can also see proposed transport corridors set out.
Yeah,
So how is
green
the
dotted line? Sorry.
Yes. So how's the strategy which you've just described depicted here?
Well, it depicts it very clearly. I mean, if we focus on Cambourne and Bourne Airfield, the allocations are depicted there in blue and a sort of a tan colour, and we have there a proposed transport corridor offline shown, which I think on any reasonable view, and if you look at the text in the local plan, that's referencing C2C.
And how can this, if the strategy is to promote new settlements beyond the green belt,
Mhm.
can this strategy be delivered without the public transport infrastructure?
Not without causing gridlock on the roads, no.
So is the
yes.
public transport infrastructure part of the strategy?
Yes, it is. It's clearly part of it. It's front and centre.
And if we then go on in that document to page 16 in the PDF, and if you've got the paper copy, I'll be able to give you the paper copy 269. We've got a figure 77 spatial framework for policy SCBN, which is Cambourne North.
Yes.
So we've looked at what might be called the big picture, Cambridge, Greenbelt and new settlements. And then when we get to Cambourne, does that rely on public transport infrastructure or not?
Yes, it does. We've got reference to the proposed east-west rail station, and we've then also got high-quality public transport route, both explicitly identified.
Yeah. And if we just go down to page 18 PDF 271 paper, and we get to 3.3.13, which is your gridlock, related to your gridlock point. There's a reference to development at Cambourne will be subject to a vehicular trip generation budget to ensure that development does not result in unmanageable congestion on the surrounding road network. So if you set a trip budget for vehicular trips, how do people then get about if there's a limit on car movements?
Well, it relies on a reliable and efficient public transport system to take up the slack and to facilitate that modal shift.
And if we look at the detail of the allocations, or that's the overall strategy, and if we go back in the same document to page should be 258 in your copy, and in the PDF, I think it's page 5, we've got Cambourne North. And I think if you could just take us through, Mr. Kelly's done this, so we don't need to do it in great amount of detail, but the extent of the development which is envisaged in the emerging local plan at Cambourne North, Cambourne West, Cambourne Business Park, Town Centre and Bourne Airfield. Or if we deal with that compendiously, then we won't take up too much of our allotted time.
Well, starting with Cambourne North, this is a new allocation. It's for 13,000 homes. Incredibly significant and strategic in its level. Plus 108,000 square metres gross internal of new employment space. So we are talking about a very, very significant amount of new development, which is a step change from where we are with Cambourne, with the current allocation for 3,000 odd plus the allocation at Bourne End.
Bourne Airfield.
Bourne End. Bourne Airfield. Bourne End's in Buckinghamshire.
Yes, there we go. Be a more extensive transport scheme.
Yes.
So we got Cambourne North, very extensive.
Yeah.
Cambourne West, we need to go to page 27 in the PDF.
What is it in the
That's page 280.
280?
And we've got paragraph 12 there, and we've got the transport strategy and transport assessments, and A, making on-street provision for possible expansion of Cambourne to Cambridge guided busway, and B, providing high-quality segregated bus priority measures on the A1303 between its junction with the A428 and Queen's Road, Cambridge. So to what extent are these proposals dependent on high-quality bus measures?
Very dependent, and goes to my point, especially with the trip budget proposals as well. I don't see how this level of growth at Cambourne North and Cambourne West and at Bourne Airfield can be facilitated without very significant investment in public transport.
And if we deal with this as quickly as we can, page 36, and that is in the PDF, which is page 289. In the paper copy, we've got 3352. So we're dealing there with the business park, reference to the Cambourne to Cambridge busway, accessibility of the business park to the wider area and region will increase significantly, and therefore the councils expect the undeveloped plots within the business park to come forward for appropriate employment uses during the planned period. So we've discussed housing, you have referred to employment, but is it just the housing which is dependent on this scheme, or?
No, it's not. I mean, clearly, in an ideal world, people live in Cambourne and at Bourne Airfield and work in the adjacent employment provision. But that's not how the world works. So, again, it's important that there are efficient, reliable links between these sites west of the city and the city itself, because there's bound to be movement to and fro. So that's why it's important to have a fully functioning two-way provision. If we're going to, and we may come on to this later, but and how this is why the C2C scheme is preferable to others that have been promoted by others, to my mind, in that it's a fully functioning two-way proposal.
Yeah. And 3354 under the heading Cambourne Town Centre on the same page. Same question in relation to Cambourne Town Centre and the aim of making it a more attractive business location.
Yeah, well, I think there's two things there, aren't there? There is a more effective business location and a destination in itself as a town centre. So again, goes back to the same point. To assist with that, it is important that we've got these effective two-way public transport links. Not everyone will come up with transport, but with the step change in the scale of development and with the issues that have been identified insofar as existing congestion and restrictions around use by the private car, it seems to me that it's absolutely central to the success of this policy to have in place C2C and other sustainable modes of transport.
And Bourne Airfield, we looked at it in the adopted local plan, but just let's have a look at emerging local plan. So it's page 70 PDF, 323 in the paper copy, and we've there got 19 public transport improvements must include, and we get A, B and C, and the C, does that mirror the adopted local plan or take a different approach?
It mirrors the adopted local plan.
So overall, on the emerging local plan strategy, what would the effect be on the strategy if the Secretary of State were to decide not to make the order which is before this inquiry?
I think it would significantly undermine the council's ability to deliver that strategy.
Or would it be possible to deliver it?
On the basis of the evidence and the approach that these councils are taking insofar as the emerging local plan is concerned, no, it would not.
Thank you. So that's all I'm going to ask you about the local policies, because Mr. Kelly has spent time explaining that to the inquiry. National policy now, and this is, we're going to come back to other elements of national policy, but this is national policy in relation to the local plan, and here I'm going to ask you a question in relation to the conclusion that you draw on the development plan. So first of all, before we get to the national policy, you've indicated that there is compliance with the development plan.
Correct.
And is that the development plan as a whole or parts of it? Or?
No, I think when read as a whole.
Right. So if we take up the MPPF, go to paragraph 11, the presumption in favour of sustainable development, and we read 11C, for decision taking, this means approving development proposals that accord with an up-to-date development plan without delay. Is that policy engaged in this case?
Yes, it is engaged, and this, in my view, is a development proposal that does accord with the up-to-date development plan, i.e. the city plan and the South Cambridge plan.
And matter of law, so not for you, but you will be aware that Section 38(6) of the Planning and Compulsory Purchase Act 2004, which is at the fore in many planning decision-making processes, doesn't apply when one has a request that the Secretary of State make a direction that planning permission be deemed to be granted. Does the fact that Section 38(6) does not apply affect the policy in paragraph 11C?
No, it doesn't.
And in terms of national policy, you referred to the case for Cambridge, which we've got in the core documents. We've also got the letter from Matthew Pennycook to Mr. Freeman setting up the Cambridge Growth Company. For reference, I don't think we need to turn it up. Case for Cambridge is CD 701, Pennycook letter CD 739. But have you considered whether the C2C scheme proposals are consistent or inconsistent with that general policy approach?
I have considered that, and yes, it is consistent with that approach. And there are specific, again, without turning up the documents, I can, if that would help the inquiry, but there are specific references in the case for Cambridge and in the Pennycook letter that identify issues around congestion in and around Cambridge and make it clear that steps are to be taken to address those issues.
So you've expressed a view on whether it would be possible...
Yes. Sorry, Mr. Chairman, sorry to butt in. But the Pennycook letter in particular, which is CD 739, says, I'm sure you'll be familiar with it. I'm coming to this inquiry quite late. I'm sure you've read this many, many times. But there are a number of references there to congestion being an issue in Cambridge that the government is aware of and is looking to address. And it says, Deputy Prime Minister and I, Mr Pennycook, are determined to help overcome these constraints and for central government to work with local partners to support sustainable growth in Cambridge and its environs. Well, that goes to the very point that we've been discussing for the last hour or so.
And if we go in that document to page 4, and I think in the paper copy there are page numbers at them.
Sorry, which document?
We're in the
CD
Pennycook
739.
letter,
Yeah.
So,
739, page 4. And we got priorities on page 4. Development acceleration, infrastructure first, support the development of an infrastructure first growth plan, unblock existing development, third bullet point, and then a business plan. So taking Bourne Airfield as an example, where you've got a condition preventing more than 500 homes being put forward without C2C or equivalent. Would this proposal unblock that development?
absolutely, it would, yes. And I think the fact there's the reference there to infrastructure first, that one of the biggest impediments to large-scale development in this country is the lack of infrastructure to support that development, and it's so often the case that the infrastructure follows the development rather than being there ahead of the development. When I'm experiencing this in Oxfordshire, where I've secured an allocation for 3,500 houses and 1 million square feet in old money of science and tech space at a place called Land West of Culham, and that is dependent on a HIF scheme which should have been built 2-3 years ago, and it hasn't been built, and so nothing has happened. And this is there's a story all over the country about this, isn't there? Where that lack of infrastructure is a major impediment to delivering on new housing and growth.
And Mr. Kelly, when he gave evidence, explained in relation, I think, to an example of Bourne Airfield, that even if you have a limit of up to 500, you also need developer confidence to start the development, knowing that the infrastructure is going to be in place. Do you have a view on that point?
I do. My experience over, as I had to say, 42 years, is that developers, in that regard, are risk averse. They will not commit to certainly major strategic development until there is certainty around infrastructure provision, and that's what's happening at this site I mentioned in Oxfordshire, where the allocation was confirmed in 2022, and nothing has happened. They haven't made an application yet because they're waiting for the certainty of the new HIF road being built, and we're now told that the work on that road is to start in January, which will then be a catalyst for the planning process to begin. So we are some years away from delivering housing, and that's a story that we hear all the time. I've got another site for up to 5,000 houses for the DIO, where that is highly dependent on new infrastructure, and I know for a fact it will not get delivered in anything like the timescales that have been mooted through an adopted and emerging local plan because of issues around infrastructure, in particular transport infrastructure.
So if it were to be suggested, well, don't worry, 500 houses can be developed at Bourne without this scheme, and Cambourne West can go ahead without the scheme, would you have that confidence?
No, I would be very surprised if the developers would, especially in the current climate too, of more general uncertainty around the economy, I'd be very surprised if they would bring forward development ahead of that provision being made.
And how does that then affect the judgment and planning balance when considering whether to make this order?
I think it's very pertinent. I think it does affect it in that delay can be a material consideration. There's case law about this. And I think it's important that, my own view is it's important that there is clarity and certainty over schemes of this magnitude and of this scheme in particular, such as to give the development industry and councils and others the confidence to start to deliver on what is, as we've discussed already, not only emerging policy but adopted policy.
Right, let's move on now to a different topic, which is heritage balance, if we can. And Mr. Ralph Lewis deals with heritage at 5:11 in his proof at page 58, and he then comes to the conclusion that the public benefits demonstrably outweigh the identified less than substantial heritage harm, applying the MPPF approach.
Yeah.
And I'm not going to ask you about whether Section 66 of the Planning Listed Buildings and Conservation Areas Act is engaged or not, because it's engaged when making a decision on whether to grant planning permission, same point as the Section 38(6) point. Section 72, assume that does apply, because it's any function under the Planning Acts, which a direction would be a function under the Planning Acts. But leaving aside the legal position, I'd like you to approach it on the basis of the policy, and note that the Court of Appeal have told us that if you work through the policies in the MPPF, then you meet the Section 66 requirement.
Yeah, so the short point is that great weight to heritage assets still does apply.
Yes. So when you're doing your heritage balance, if Section 66 is engaged, considerable importance and weight to the desirability of preserving the setting of the listed building, but in any event, the policy says great weight.
Yes.
So I'd ask you to assume great weight and leave the perhaps not very interesting legal points to others.
Well, it is quite interesting, but
yes. But we will address you on that in closing. So I'm just raising it because you will want to think about that. So we have a heritage balance and the conclusion Mr. Lewis comes to. Do you agree with his conclusion?
yes, I do.
And what I'd like to ask for your view on is, he's assessed the heritage balance on the basis of Mr. Wilson's assessment of harm and the levels of impact that he identifies, and you agree with him on that.
Yes, I do.
But if the inspectors took the view that the level of harm to the heritage significance of Clare Hall was less than substantial at the middle of the range rather than at the lower end of the range, how would the heritage balance be struck?
The heritage balance would still be struck, in my view and my professional opinion, in favour of the development, because of the wider public benefits that will accrue from it being approved.
Yes. And if you have a scheme which you've said without which the emerging local plan strategy could not be developed, or it would have a material impact on the strategy. Is that a factor that goes into the public benefits side of the balance?
Yes, it is. Yes.
And if only limited weight can be given to the emerging local plan, does that factor, combined with the other factors, still outweigh the heritage harm?
Yes, it does, for all the reasons that I've expressed this morning about the the consistency and approach between the development plan and the emerging local plan, and when one also factors in government's intervention in development in Cambridge and the other matters we just discussed recently. Yes, absolutely. I need to get some water.
Yeah. So that's the heritage balance. Now I'd like to go to Greenbelt. And in your note at 521, so we're on core document 2962, you say that you've read the Greenbelt assessment, you've read Mr. Lewis's own assessment, you're surprised that it had been divided into a series of sub-areas. You would have expected it to have been considered as a whole.
Yes.
But you're content to adopt its findings and the assessment carried out by Mr. Lewis.
Yes, there was a rather pedantic point about the division into sub-areas, but I would have thought that the assessment would have been more about the impact of the scheme taken as a whole, but it reaches the same conclusion is reached. As I say, it's a pedantic point.
Right. Well, let's just have a look at it. Overall then, we know we have local Greenbelt purposes set, we don't need to turn it up, Cambridge Local Plan, Table 2.4, and for your references, sirs, it's CD 601, page 36. And then we have the MPPF, which is where I'm going to concentrate on this, core document 8.1. And we're going to go to page 44, where we have a heading, Proposals Affecting the Greenbelt. And if we, at the same time as having the MPPF to hand, if we can have our Ralph Lewis's proof, page 37, 5515.
Page 37.
Page 37, there's a table,
Yes.
and in that table he assesses the scheme against the 5 Greenbelt purposes, and the results are summarised below in table 3, and we know that you agree with his assessment because you've told us that in your note. And he also has in his rebuttal, just for us to note, at 5.5 in the rebuttal, there's a response to Mr. Littlewood's evidence on the purpose of the Greenbelt. So that's where all the information is to be found. And then we have in Mr. Lewis's proof the same section which we were looking at before, which is 5.5 on the Greenbelt. He assesses harm to openness, and we can see at 5.511 he identifies a particular harm arising from the travel hub.
Yes.
And we also have on openness as opposed to purposes, we have his rebuttal 5.3 where he responds to Mr. Littlewood on openness. But having adopted his evidence, I'd like your overall view on whether a very special circumstances case is made out or not.
My overall view is that it is made out, and in that regard, I do adopt Mr. Lewis's conclusions, and Serge, you will have also seen my note on the point.
Thank you. We won't. We'll leave Greenbelt at that for now. We're going to go to veteran trees now. So we're still on the MPPF and policy there. So we're going to go to 193. It's on page 56. And again, Ralph Lewis has dealt with this matter in his evidence, as one would expect. 5.8.44, where he's dealt with wholly exceptional reasons. Now, the evidence is that there wouldn't be loss or deterioration of veteran trees because they're going to be translocated. So my question is based on the hypothetical basis that a different view is taken and that there is either loss or deterioration of the veteran trees because, for whatever reason, inspectors take the view that the translocation won't work or for any other reason.
Mr. Cameron,
Yes.
before we go further
Yeah.
with the question, I'd just like to be clear about Mr. Sensical, and because it's built on Mr. Lewis' understanding of the veteran trees, with reference to page 17 of Mr. Sensible's notes. The query is how many veteran trees you take into account. You have clear evidence of this from Mr. Older, and I think the different position taken in your note.
You think there's a different position taken in my note?
Yes. I'm looking at your table on page 17. The top half of which is impacted on cross-melody. This is just a carry forward from Mr. Lewis. You refer to two veteran trees.
Which page 17, sir?
Yes.
Yeah. I do refer to two, and that is a carry forward from Mr. Lewis, yes.
But
Because that's the information I had at the time.
And have you taken that number into account in reaching your view? That's the consequence.
so we also have to go to 524 where he refers to 3.
Yes, I know. The numbers vary.
Yes.
My 524. Did you say?
Yes, 524, page 10.
Yeah. So what's happened is I've transposed the words in the table were transposed from Mr. Lewis's evidence, and there's clearly an inconsistency. But I am aware that it's 3 trees that are affected, and
It's more than.
Well, sorry, there are three veteran trees. Yeah, there are more trees affected.
Yeah, reading your term suggests that there are only 2 in total.
Yeah, which is clearly wrong. I accept
Yes,
that.
it is.
Yeah.
524 in your note, Mr. Sensible, you have, on the basis that the 3 veteran Bramley apple trees in the Coton Orchard that are within the footprint of the guided busway
Yeah.
can be relocated, there will be no loss or deterioration in these irreplaceable habitats. So if the 3 which are proposed for relocation for some reason do not survive and there is loss of deterioration, and assuming that the others which do not have to be moved, the other veteran trees, remain in place.
Yes.
First question I'd like to ask you, so if we're talking about 3 that have to be moved, if there is loss or deterioration, are there wholly exceptional reasons or not?
There are still wholly exceptional reasons as to why they should be moved, yes.
Well, not whether they should be moved,
sorry.
but going back to the policy in the MPPF, so if there is loss or deterioration
Yeah.
of those 3, the policy is that the development should be refused unless there are wholly exceptional reasons and a suitable compensation strategy exists. So if premise for the question, for the moment, loss or deterioration of 3, because the translocation doesn't work, but there is a suitable compensation strategy elsewhere, not the relocation, but another suitable compensation strategy. Is there a wholly exceptional reasons case made out?
Yes, it is.
And can you explain why that is?
Well, it's as we've been discussing the whole of this morning, the importance of this scheme, that the C2C scheme provides that exceptional case. And yes, I come to that view based on the fact that there is a suitable compensation strategy in existence if required. And I don't think whether we're talking about 2 trees or 3 trees is, well, it does not change my conclusion.
Okay, well, next question is if you had not just the 3, because there are some on the beside towards the boundary of the order limits. Those are the 3, so just for your note, T5, T9 and T10. It's Mr. Alder, page 10, he's got an image 4. So if it wasn't 2, it wasn't 3, but it was 6, this is all contrary to the applicant's arboricultural evidence on this, but suspend your disbelief for a moment, hypothetical. Would wholly exceptional reasons, assuming there's a suitable compensation strategy, be made out if it was 6 rather than 3?
Yes, it would.
And again,
Given the magnitude of the C2C scheme, given what it unlocks in terms of housing and employment, given the priority given by the local authorities and government to further growth in and around Cambridge, yes, that case is made out.
and just while we're looking at that, and you've still got the MPPF to hand, when we're looking at wholly exceptional reasons, we see there's a footnote 70. And does the proposal fall within any of the examples given? They are just examples.
It falls four square within the example given, Transport and Works Act, nationally significant infrastructure projects.
Where the public benefit would clearly outweigh the loss or deterioration of habitat.
Which is the point I'm making, that there is a very clear public benefit from this scheme.
Right. Well, I hope, sir, that clears up that issue on numbers. Thank you for raising that.
Yeah, thank you for raising it, sir.
Can we now, while we've got the MPPF to hand, and we're dealing with this just as we can on the MPPF, can we turn to a completely different subject, flood risk, and this is covered in your note, and you've drawn attention here to, so this begins in your note, page 11, water and flood risk. And you refer again to Mr. Lewis and his conclusion, but you then draw attention to changes to the planning practice guidance, and you set out the changes that were made in September.
Yes.
After the inquiry began. So we note that, but we go back to the MPPF if we can, and we're going to deal with this in what might be said to be the wrong order, but we're going to do the exception test first. So we're going to go to paragraph 178. And I'm not asking you about the facts here, I'm asking you about the policy. And if you've got 178 in the MPPF,
Yes.
to pass the exception test, it should be demonstrated that A, the development would provide wider sustainability benefits to the community that outweigh the flood risk, and B, the development will be safe for its lifetime, taking account of the vulnerability of its users without increasing flood risk elsewhere, and where possible will reduce flood risk overall. Now, Mr. Southern has dealt with B, so I'm going to ask you about A. If this test is engaged, would A be satisfied, or would it not be satisfied?
It would be satisfied based on the evidence that I heard from Mr. Southern, but clearly in terms of the sustainability benefits of the scheme before this inquiry.
And without rehearsing them all, what are the particular sustainability or the broad range of sustainability benefits that you rely on?
Facilitating a move away from the private car, facilitating growth in housing and employment, consistent with government policy and with the adopted local plan and with emerging policy, and doing so in a sustainable way.
Thank you. So that's exception test. Now the sequential test, and again Mr. Southern has given some evidence on this. So it's 174 in the MPPF, second sentence, development should not be allocated or permitted if there are reasonably available sites appropriate for the proposed development in areas with a lower risk of flooding. Now here we're dealing with the eastern end of the scheme, where it comes into Grange Road. Before that it crosses the Bin Brook, and there are areas of flood risk areas.
Yep.
And an alternative of going along Adams Road is considered as part of the options assessment process. And Mr. Southern has given evidence that the alternative route on Adams Road is not an area at lower risk of flooding, and you may not have been here for his evidence, but he gave evidence and he produced the flood risk and referred to the flood risk maps the junction of Adams Road and Grange Road and showed the flood risk at that area. So
I was here for that evidence.
So if the alternative route on Adams Road is not in an area at lower risk of flooding, and if there are no reasonably available sites, or in this case reasonably available route at lower risk of flooding, is the test passed?
Yes, it is.
So is there any issue on flood risk in relation to the applicable planning policy?
No, from a policy perspective, I am content that the policies are complied with.
Right. Good. Let's go on now to different topic, open space, which requires the engagement of policy. And I'd just like to look with you, if we can, at the Cambridge Local Plan, which is core document 601. And we've got a policy here.
Sorry, could you give me the page reference again?
Yes, it's page 204. CD 601. It's policy 67, so if you've got the paper copy, it begins on 203.
I've got it, yes.
Yeah. And
Sorry, Mr. Cameron, my laptop's just playing,
it's it's page 203, sir, in core document 601. We've got a policy 67, protection of open space. And here, and again, we can take up all the drawings if we need to, but I think we've looked at this before in the inquiry. There's a proposal to replace open space taken from land east of the M11 and to replace it with open space land to the west. Now this is subject to an application under section 19 of the Acquisition of Land Act, and I think we'll deal with this at the same time as the policy, but it's the policy that I want to ask you about.
Mm-hmm.
And have you had a chance to consider this point? And so first of all, what is the policy test? And secondly, what's the answer when you apply the test?
Yes, I have considered it. I've also been to the site where the existing open space is and the site that is proposed to replace it. So the policy, development proposals will not be permitted which would harm the character of or lead to the loss of open space of environmental and or recreational importance unless the open space can be satisfactorily replaced in terms of quality, quantity and access with an equal or better standard than that which is proposed to be lost, and the re-provision is located within a short walk of the original site. From the evidence I've read and from my visit to the site, I'm clear that the case being made by the councils is that the replacement space is equal or better to the space that's being lost. There's an issue around whether it's within 400 metres, I think, but otherwise, in all other respects, the view of the applicants is that it's better than the space that it's replacing.
And while we're on this question, so that we don't have to go back to it, if we jump to section 19, the question there is it equally advantageous in terms of use and access? Your view on that?
From the evidence I've seen from others, yes, it is.
And you say you've been there yourself
Yes.
and had a look.
Yes.
Thank you. Now, jumping about a bit, but conditions are going to be addressed in the conditions session, which is going to happen later in the inquiry. And there was a draft list of conditions agreed with the councils, which are in the statements of common ground,
Yes.
which are agreed with the councils, and they're CD 29, 12 and 13. Then when Clare Hall withdrew their objection, they put forward a proposed condition 34, which would be time restrictions on use of the busway. And Mr. Lewis, Toby Lewis, in his noise evidence, also contemplated a condition which restricted hours of use. And have you and your team considered this and proposed a condition which addresses both Mr. Toby Lewis's points and the Clare Hall point?
Yes, we have.
And I don't know whether that's come in yet, sir, but if it has, and see whether it's on the website now. And if it is, we can have a look at it, and if it isn't, we'll have to look at it in the conditions session. I don't think it's on core document 29, so we can deal with it when we get to the conditions session. So I'm told it has been submitted, and I know that Mr. Sensical and his team have worked on it so that it was submitted in time. But we will, well, we can't talk about it without having it in front of us, but what have you sought to achieve?
We've sought that the Clare Hall condition was quite clear, and given that it relates to an agreement with Clare Hall, we've sought not to interfere with that condition in any way, shape or form, but to try and find a way of then melding that condition with the condition that the other Mr. Lewis proposed, in that they're both dealing with a similar point around time limitations on the running of the of buses.
And as I understand it, but we can discuss it in the conditions session, Clare Hall understandably were interested in the eastern end, but Mr. Toby Lewis has taken a comprehensive view, and the condition which he contemplated has a restriction at the western end as well. So that's why we're looking at both.
Yes, and there needs to be consistency between the two.
Good. Well, we'll all wait with bated breath till that comes up on the website.
Yeah.
Oh, now.
Is it there?
Well, Ms. Vincent's just given a signal that it is, but perhaps she could give us a tip as to where it is.
29-96.
Oh,
Oh. Do we have to come out and go back in again? For it
oh, you have to refresh. That's what I've. Yeah,
Oh, Lord.
jolly good. Well, let's open that up and see whether it lives up to the expectations that have
Can I-
been.
Sorry, I missed. Yeah,
It's
no,
the
I'm
last
just- I know,
one
I'm
in.
just trying to refresh the page.
You have. That's because I looked at it and. In the old days, we'd all be scrabbling around for a printer for it all to be printed out, but now we get it.
Disappeared.
You got it?
Yeah.
Fantastic. Condition 34. So we've got that condition, so it has east of Charles Babbage Road, the Clare Hall bit, and then we've got at 3 to the west of Bourne Airfield.
Yep.
Anything more to say on that?
Not unless the inspectors have got any questions, but as I say, we were trying to meld the two provisions together into one condition. We felt that was the simplest and most straightforward thing to do, and I think it achieves what we were setting out to achieve.
Good.
I have got a question about it, but I'll save that until later.
I think there are going to be some detailed questions.
Yes. Well, that's why we were keen to address it in evidence, so that there would be a chance to deal with the questions in evidence, and if there were changes needed, we can make them before the conditions session. Next subject, please, Mr. Sensical, and that is Secretary of State's main issues, which the inspectors will want to address. Mr. Ralph Lewis deals with this in his section 7, and does that stand as your, before we come on to the planning balance, does that stand as an assessment of the main issues, or
Yes,
from the planning point of view?
I've been through them again the last couple of days, and I'm content that that still stands as
Right.
a proper reflection of our response to those main issues.
Good. Now, the next and last topic is the planning balance, and it may be, sir, if you want to take a break, that this is a good time to do it. And planning balance, Mr. Sensicle's got his table, and I'm just going to ask him to talk to his table.
Yeah. This is a good time for a break. We'll take one now and resume inquiry at 11:25.
Mr. Sensical, we were going to go on to the planning balance, and you deal with this at section 6 of your note, and you say that you agree with Mr. Lewis that the benefits of the scheme far outweigh the identified harm, and you've produced a table and you've used 3 levels of harm: limited, significant and substantial. And in a moment I'm going to ask you to speak to your table and explain it and your attributions of weight, and I'll try not to interrupt you while you're doing that. But just before we do that, Mr. Littlewood put in a response to your table. Saw you'd done a table, so he thought he'd do his own. Quite fair enough. And that's in 2968. And he says also that you haven't considered impact on land owners. And so with those 2 points in mind, and you may wish to respond to Mr. Littlewood when you're doing so, would you like to take the inspectors through your table and just explain how you've approached the balance, and how the table helps in explaining the way that you've done it?
Okay. Well, I think as we discussed earlier, what I did was to take the list of benefits identified by Mr. Lewis, and then simply to attribute the weight as I saw it to those benefits. I also then took Mr. Lewis's indications of harm and did the same with that. So, simply trying to say, right, what are the benefits and how much weight do you attribute to them? What are the harms? How much weight do you attribute to that? And then I come to a balance. It's not what I would call sophisticated, but I find it quite a helpful way of just trying to clarify where I think things are, having considered the case as a whole. So under benefits, one of the key benefits of this scheme, as we've discussed this morning, is unlocking housing growth. And that's housing growth in the adopted local plan. So there's a development plan imperative to delivering that housing. But also in terms of the emerging plan, which we now have, which we didn't have in its current form at the point that I wrote this. And it's now clear that emerging local plan is consistent with and builds upon the policy direction in the adopted local plan. And what that does is go to further, I think, emphasise my view that that substantial weight should be given to the provision of housing, the ability of C2C to assist in the delivery and provision of housing. The same goes with my second point, which is about employment expansion. That what we have here through the adopted local plan and the emerging local plan is a balance between housing and jobs, and a continuation of the policy of trying to consolidate growth in housing and jobs to the west of the city and elsewhere through other policies. And again, that I attribute substantial weight to. Placemaking is another point. I mean, we're in Cambourne now. It is a place. There's a lot more development proposed in Cambourne through the emerging local plan, both housing and employment provision. We've talked this morning about the fact that it will become more of a destination than just a place where people live. And I think for that aim to be achieved effectively, we need the Cambourne to Cambridge scheme. And again, I attribute substantial weight to the delivery on those objectives. Transport, which is obviously the primary purpose of the Cambourne to Cambridge scheme is to deliver a means by which public transport can get into and out of the city and can link the committed and planned growth to the west of the city with the city itself. So again, given that's the raison d'etre of this proposal, I give that substantial weight, and I, in support of that view, go again to the more recent pronouncements around the case for growth in Cambridge and government support for those initiatives. Then we go on to the inclusion of an active travel path, which is integral to the scheme for cyclists and pedestrians and equestrians. That is a further benefit of this scheme, and again is consistent with policy around active travel, around getting people out of their cars, and I give that significant weight, and I give it significant rather than substantial, in that I think in terms of the numbers of people that will benefit from that, the bus provision is about large numbers. One would hope that there'll be a significant increase in active travel, but I think the reality is that in terms of numbers, it's not as big a benefit. So that's why I've given it significant rather than substantial benefit, but it's still clearly a benefit. Similarly, the Scotland Farm travel hub, that is integral to the scheme. It picks up those coming further from the west, but they will have to travel there by car to get to the hub. So I've given that again significant weight. Air quality improvements. When it's up and running, and especially if we can get to a point where we've got electric buses, there should be a substantial improvement in air quality as a result of this proposal, and accordingly that's the weight that I've given it. Climate and greenhouse, there are some savings, but I've given that for the reasons set out, limited weight. Biodiversity net gain, we are signing up to a minimum of 10% and hoping to get to 20%. That is significant in my view. Yes, there is a policy presumption that one will get to 10%, although I'm not sure it applies in this case. But the very fact that the promoters are looking to get beyond 10% towards 20% is significant in my view. I then so that's in the positive column, and then I turn to harm.
Just before we
Sorry.
move to the harms, on the climate and greenhouse gas benefit,
Yeah.
you put in the figure which is quite properly taken from the evidence of around overall net savings around 5,000 tonnes that you put in limited.
Yeah.
If the saving was lower than that, but was still a net saving, would that still be limited, or would it change?
No, I think it would still be limited. Yeah. I mean, there's a spectrum, a range to these things, and it's a judgment call. But I would still give that. If we're in the positive column, I would give it limited weight in terms of being a benefit of the scheme.
Thank you. Sorry to interrupt. You were going to come on to harms.
So, quite properly, Mr. Lewis identified various harms, and again, I set those out. The first one is the impact of cotton orchard. I I've concluded that on the basis of the evidence that there is significant harm to that county wildlife site, and I've given it that weighting. Biodiversity impacts, there are myriad biodiversity impacts, but I think overall, from what I've read and from the approach taken by Mr. Lewis and others in his team, I am content that that should be as set out. So limited impacts. Then I've looked at temporary landscape effects during construction, and I acknowledge that they will be significant, but they are temporary. Permanent landscape effects, a lot of evidence has been given around the landscape impacts of the scheme, but I think a lot of care has been taken in terms of the alignment of the proposed busway, such that consistent with the evidence given on landscape impacts, I say that is in terms of the permanent effects, that will be a limited effect. Noise and vibration could be, well, I've said significant, but that is in relation to the construction phase, so it is temporary. And then the final one is the loss of agricultural land. We lose 39 hectares of best and most versatile land, but that loss needs to be weighed against the benefit. And I think in terms of the scale of this project, that there is limited harm from the loss of that land, is my view. So, and then if one looks at the benefits I've attributed to the various matters I've discussed and the harms, we have far more substantials and significance in the plus column than we do corresponding categorizations in the negative column, and that leads me to my view that the scheme, the benefits of the scheme clearly outweigh the harms that would arise from it.
Thank you. And you mentioned earlier in your evidence that delay is capable of being a material consideration in these type of schemes.
Yeah.
So I'd like to just explore that for a moment. So assume for the moment consequences of not making the order, delay that would follow, and a range of figures that we have before the inquiry. Mr. Freeman up to 10 years, Mr. Baker 5 to 10 years, Mr. Lee up to 5 years following decision on the order application. Now, if you had a delay, let's say in the order of 5 to 10 years, if the order were not to be made, what would the impact be on the local plan strategy, taking account, let's say we're now in November 2025, let's say we have a decision in mid-2026, say June 2026, and we have a 5-year period which takes us to 2031.
Yeah.
And we have a local plan which has a current adopted plan period 2011 to 2031. So what effect would that have on the local plan strategy?
If the order isn't confirmed, it would have, in my view, have a significant effect on the local plan. Well, sorry, no. In terms of the weighting, I think it's a substantial effect on the ability to deliver on the plan's objectives.
And so if we look also, have you got core document 763 to hand? Well, you won't have it to hand at the moment, but if you could find it, please. And that's the inspector's report on the South Cambridgeshire local plan.
Another one I printed off.
And if you go to page 20,
Says that's CD 763.
763, yeah.
Yep.
And if you go to paragraph 84, can we see of the inspector's report, and at that time, so 84, at the time this matter was considered at the examination, a certain amount of work had been undertaken investigating options for what is known as the Cambourne to Cambridge Better Bus Journeys project, but no clear route alignment has been confirmed. And then reference to the City Deal Executive Board allocating money, and we consider that there is a reasonable prospect that the scheme will be completed during the planned period. So what was the
i.e. to 2031?
Yeah, so what was the premise on which the local plan was found sound in relation to the C2C scheme?
The premise was that there was a reasonable prospect that the scheme would be completed, and would therefore facilitate the bringing forward of development on the allocations at Cambourne and Bourne Airfield.
And if it isn't completed by 2031?
It's going to affect the ability to deliver on that basis.
And if you have Mr. Lewis's rebuttal to hand, and you go to page 8, and he's got a slightly more pessimistic timescale than the one I asked you to assume, which was decision by June 2026. He's got it September 2026. But so if you, so that is a, if you take that time scale and construction happens 2030 to 2032, does delivery occur within the current local plan period?
No, we're just outside.
Yeah. Now, is there anything you've seen Mr. Littlewood's response, and I asked you about, he says you haven't taken into account effect on landowners, but from your planning balance perspective, have you taken into account effects on land use in your planning balance, including impacts on ability to farm the land and so on?
I've taken full account, in my view, of the land use impacts. That's what I do. Right. Yes.
So is Mr. Littlewood's criticism that you haven't taken into account impacts, he put it on landowners, but I've translated it into a planning point, land use. Is that a fair criticism of you?
No, I'm not sure that I fully understand what he's getting at in terms of the impact on landowners. If it's impact on their amenity, I think that has been taken into account. If it's something else around value, for example, I don't think that is a matter that I should be taking into account in a planning sense at this inquiry and giving evidence.
And if it's on ability to farm the land, have you taken that into account?
Yes, I mean there's been evidence from a number of witnesses as to. I mean, there was some discussion yesterday around that and about the alignment of the road. That has been taken into account.
Thank you. Is there anything else you'd like to add before hand over to Mr. Parker?
No, I think I've said all I wanted to say.
Thank you very much.
Thank you, Mr. Cameron. Mr. Parker, your turn to ask questions.
Thank you. Good morning, Mr.
Good
Sensical.
morning, Mr. Parker.
Thank you. I just want to start by asking some questions to clarify the scope of the evidence that you give. As I understand it, you're giving evidence essentially that in large part you inherit from others, and you then apply the relevant planning policies to that evidence and weigh that evidence in the balance. Is that sort of fair?
That's a fair summary.
Summary of the approach that you've taken. So, for example, when we come to the issue of transport analysis, the claimed journey time savings that would result from the applicant scheme, that is evidence that you've inherited from others. You accept that evidence as given, and then you apply relevant planning policies to that analysis and weigh those matters in the planning balance.
That's fair, yes.
That's fair, okay. So for the purpose of my questions, I am going to avoid those areas where there is dispute or agreement between the parties in respect of the underlying analysis, the underlying evidence, and to focus very much on the planning policy consequences and the planning balance, and to deal with those issues where you do express views that aren't, as it were, inherited from others. Okay? So the first topic I want to ask you about is the green belt. Now, it is accepted by the applicant, by you, that the development is inappropriate development in the green belt, and that there would be some harm to the openness of the green belt by reason of the development. That's a matter of agreement between us, isn't it?
It is a matter of agreement between us. That harm to openness is principally around the Scotland Farm transport hub.
Sure. But when we're looking at the section of the route to which the CPPF alternative scheme relates, so that's a section of the route between Madingley Mulch Roundabout and the M11 and the campus immediately to the east of the M11, that alternative section of the route. It's right, isn't it, that so far as that section of the route is concerned, the applicant scheme would pass through the green belt, and I think, I understand your position to be that there would be some harm to openness as a result of that part of the scheme, albeit that there's a dispute between yourself and Mr. Littlewood as to the extent of the harm to openness. Is that right? Is that fair?
That is fair, but I think it's also important to say that changes that would be required to the alternative online route proposed by your clients would also potentially have some effect.
Okay.
On openness.
Okay. Well, I hadn't understand that to be your position. Where's that set out in the written evidence before the inquiry?
It's not. It isn't insofar as my evidence is concerned. But you've asked me the question. And
I didn't actually ask you that question.
Well, okay. You asked. You referenced your client's alternative route.
Yeah.
So I think it's fair. Well, having accepted your proposition, I think it's reasonable for me to then give you a view on a directly related matter.
Okay, I'm not saying it's not, but my question wasn't directed to any effects of the CPPF alternative.
No, I know it wasn't, but it's
so
you
there we go.
raised it, so I'm responding.
There we go. Well, let's.
I'd like to hear the answer.
I know, I understand that, but when it's suggested that I've asked a question, I haven't asked a question. I'm going to correct you. I'm going to pick you up on that, Mr. Sensko. I think that's fair. But we'll get there. But it's. Okay, well, I mean, I'm going to come on to that topic, but okay.
Right, so as I mean, we don't have a fully worked up scheme from you to the same detail that we have, but even with the online scheme, there's some widening required, and there'll be the need for additional signage and other if you like, transport paraphernalia. And so I don't think it would be right to say that your alternative scheme would have no additional impacts on openness. Your scheme also still assumes that there'll be as I understand it, the Scotland Farm transport hub.
Yeah. So we can assume that. Let's ignore the Scotland Farm Transport Hub, but
Well, we can't ignore it.
there's no dispute between us in
No.
relation to that topic.
Yeah.
The inspectors, I think we want to save our time and resource at the inquiry to those issues where we're in dispute. No dispute between us about Scotland Farm.
Yeah.
That's not what the CPPF alternative is about. So let's focus on, firstly, your suggestion that there would be some harm to openness of the green belt as a result of the CPPF alternative. I want to ask you some questions about that. Because obviously there is an existing road, Madingley Road
Yeah.
corridor, which you would accept, I assume, is harmful in and of itself to the openness of the green belt insofar as there is that harm, yeah?
So, yeah, a low level of, but yes.
Okay, low level. And yet you're suggesting that the addition of a bus lane and some widening would give rise to a material effect on the openness of the green belt in that corridor. That's your professional evidence to these inspectors.
Yes, it could. I don't think we've seen the full detail around your alternative scheme to form a final view on that, but that it has that potential.
Okay. Well, in terms of the detail, Mr. Sensical, you have sufficient detail, don't you, to be able to give an informed judgment as to whether the minor widening works to the carriageway that would be required to deliver the scheme are likely to have a material effect on the openness of the green belt, given the existing main road that runs through that corridor, don't you?
Well, you say minor widening. I don't know. I'm not sure I have got enough detail, actually.
Okay. The drawings are before the.
To make the proposition that there could be further harm to openness, but I don't think I have the same. Well, I don't have the same level of detail as the applicants have provided.
I mean, Mr. Sensical, that with the greatest respect, that's absurd. There is no conceivable way in which the minor road widening works that would take place to the existing Madingley Road could conceivably have any material impact on the openness of the green belt, is there? Come on.
I don't accept that, no.
Okay.
I think without
Well, there we go.
details of that scheme, I don't see how. Well, I can't agree with that. No, I
Okay.
can't.
Well, we'll leave that one with the inspectors.
Yes.
They'll take their own view. But on any view, if one is comparing the applicant scheme, which runs through open farmland, currently unencumbered with any development at all in this location, bar where it crosses existing roads and so on, if one was to compare the effect on the openness of the green belt of the applicant scheme by comparison with the CPPF alternative, there is really no comparison, is there, Mr. Sensical? The applicant scheme is, on any view, materially more harmful to the openness of the green belt than the CPPF alternative. That's right, isn't it?
It's only a fair and reasonable comparison if the alternative scheme is deliverable. And
Yeah, that's a different question, Mr. Sensical.
It's a very real issue.
Yeah.
If it's not deliverable,
we've had lots of evidence on that, and as I said at the outset, Mr. Sensical, I'm not going to ask you about topics which we've already had lots of evidence on. My question is about comparative harm to the openness of the green belt. So can you focus on my question, please?
I'm very focused on your question.
So what's the answer to my question?
I think it's reasonable and fair for me to say it does depend if that scheme is deliverable, and there are serious question marks about its deliverability.
Yeah, you've made that
We've
point.
noted that caveat,
Yeah,
but
okay.
can you answer the question, please, Mr. Sensible?
If you were staying wholly within the existing carriageway, and if you were not proposing any new signage or other technical works that were required to support the scheme, on the face of it, yes, there'd be less, and if it's deliverable, there would be less impact, yes.
Okay, I want to remove some of those caveats. If you're proposing the widening that's proposed in the civilistics drawings with such signage as would be reasonably necessary to deliver the scheme shown in the civilistics drawings, on that comparison, the applicant scheme would be materially more harmful to the openness of the green belt than the CPPF alternative in that scenario, assuming that the CPPF alternative is deliverable.
Assume, with all those caveats, yes.
Thank you. Now, just in terms of the approach to the effect on openness of the green belt, the difference between Mr. Littlewood and yourself in terms of the applicant scheme, I think, comes down to 2 points. The applicant has placed emphasis on the fact that the road itself will be visually contained within the landscape, so that, as it were, the road surface is sort of not visible. But it's right, isn't it, that the busway will involve the removal of hedgerows and so on, which currently segregate the fields and provide visual containment to the fields.
There are some hedgerows lost, yes.
And that will have the effect of opening up the landscape in those locations. That's correct, isn't it?
Well, that's an interesting point. I mean, there's the visual and spatial components to openness.
Yeah.
And we could spend a long time talking about that if you'd like to.
Well, I'm going to spend a bit of time, hopefully not too long, but we'll come on to that, yeah. But my question, in terms of the hedgerows, the visual containment that's previously provided by hedgerows and so on, if the road cuts through them, that visual containment will no longer be there in that location.
Assuming that there are viewpoints from which one sees those hedgerows.
Yeah,
yes.
Sure. And Mr. Littlewood...
If there are footpaths that from which those gaps are visible, there'll be a change.
Indeed. So one particular location Mr. Littlewood refers to is on the road that runs north-south from Coton, where the busway, which the busway will intersect with, one will have linear views down the carriageway of the busway at that point on the road. That's right, isn't it?
Linear views down.
When a linear, so you're looking down the road as opposed to across the road.
And where does the hedgerow come into this discussion? Sorry.
Well, because if you're standing at that point and the road is cutting across the fields, in those locations where there was previously hedgerows, the road cuts through the hedgerows and there's open, so you can see the physical infrastructure of the carriageway in those locations.
And are these people on the bus that will see it, or are we saying that there are footpaths from which they will see it?
No, so I've mentioned the road immediately to the north of Coton. Are you familiar with? Yeah, familiar with that location. So from that location.
Sorry to interrupt, Mr. Parker. Are you're saying road? In some instances, do you mean the proposed busway rather than the existing road? Because I'm getting a bit confused.
So I'm talking about the existing road. The proposed busway will cut across that road.
Cambridge Road, where the busway will go across. Okay.
Yeah. So are you clear about where I'm talking about, Mr. Sensible?
I am now clear, but can you just ask me the question again?
Yeah, so from those locations where one has what I'm calling linear views, so views down the busway as opposed to across it, the road infrastructure will be visible from those locations. The road infrastructure itself will be visible from those locations, yeah?
At that crossing point, yes.
Yeah, and so in those occasions, the road infrastructure will be harmful to the openness of the green belt, whether in visual terms, if not in spatial terms. That's right, isn't it?
Yes, it is, and that's why we're accepting that this is a VSC case, and we've got to show special circumstances as to why.
Well, I don't think that's quite right as a matter of law. It's inappropriate development, therefore you have to show very special circumstances. I'm talking about the harm to openness.
Yes, there is there is accepted harm to openness.
Yeah.
Yes.
I understand. I'm just exploring the differences between yourself and Mr. Littlewood in terms of the approach. So that's fine. That's helpful. Bus movements. Now, Mr. Littlewood has made reference to bus movements. Buses are obviously movable objects. No one's suggesting that they're not. They don't have, as it were, a permanent presence that would cause harm in pure spatial volumetric terms to the green belt. But Mr. Littlewood's position is that they would nonetheless be harmful in visual terms. And I just want to get your view as to whether you accept in principle that the movement of buses along the busway is capable of causing harm in visual terms to the openness of the green belt, or whether you would dispute with him on that principled basis?
This is a difficult one. As you say, they are transient movable objects. There are lots of transient movable objects and movements across the greenbelt. It would not be an uncommon sight to see a bus in the countryside.
Sorry, go on. I don't want to interrupt you.
It would not be an uncommon sight.
No, but
to see
at the moment, that part of the green belt is agricultural fields. You might spot, I don't know, the odd tractor or something like that moving across the fields, and people may take the view, well, that's entirely commensurate with the agricultural use of the green belt in that location. Mr. Littlewood's point is that one will see buses going up and down the busway, and therefore you will have the perception that there is transport infrastructure cutting across the green belt in that location that will be harmful in visual terms to the openness of the green belt. So that's his position. I just want to understand your view as to whether you say that's just not relevant to harm to openness, or whether you accept in principle it's harmful, but I don't know, you take a different view.
I accept that buses will be visible from certain vantage points where there are no buses currently, but I am not convinced that that is harmful in terms of the openness of the green belt, given that, as I say, it is not unusual for somebody to experience vehicles in the countryside when they are enjoying the countryside, because the road is littered with, so that the countryside is littered with roads, and it's a common feature that one would not be surprised to see, even if one is enjoying the countryside on a footpath or on a bike or on a horse or however else you're doing it.
Fine. Okay. Understood. Moving on then, next topic, landscape.
Yeah.
The scheme, the applicant scheme is predicted by the applicant to lead to some adverse impacts on landscape character, greater temporary impacts, but nonetheless some residual permanent impacts on landscape character. And there is a dispute between the parties as to the extent of the harm that the applicant scheme would cause. The inspectors will be required to reach a view on that. But in pure landscape character terms, again, subject, if you want, to the caveat that the CPPF alternative is deliverable. I appreciate you probably don't need to say that every time I ask you these series of questions, but subject to that caveat.
Can we take it as a given?
Take it as given, yeah. You would accept that the CPPF alternative scheme would have fewer adverse impacts on landscape character than would the GCP scheme, not because the CPPF alternative uses an existing road corridor. Is that fair?
Yes, I would.
Natural environment. I just want to check your position. Coton Orchard County Wildlife Site. I think you suggested that there was some dispute between the parties as to whether there would be harm to the county wildlife site. That I may have misheard, or you may have misspoke. I think, but it's right, isn't it? It's a matter of agreement between Mr. Whitby and Mr. Woodfield that the residual impacts to Coton Orchard, that's to say taking into account mitigation compensation, would be significant at a county scale in terms of the effect on Coton Orchard.
And I put significant harm in my balance, didn't I?
Fine. It was just something you said in oral evidence that made me want to clarify, but I'm grateful for that. Now, we've established, both in terms of the effect on bats with Ms. Reason and in terms of the other ecological receptors with Mr. Whitby, that the CPPF alternative is preferable in ecological terms because it would avoid the impacts that arise with the scheme that are required to be mitigated. Yeah, you recall that position?
I do recall that.
Yeah, and it's also right that the CPPF alternative would avoid any potential impact on veteran trees. That's correct, isn't it?
I think that's correct, yes.
Yeah.
Well, no, it is correct, not I think that's correct.
It is correct, thank you. So in both of those respects, therefore, the CPPF alternative, subject to your caveat, is preferable to the GCP scheme.
I don't think it's quite that black and white, is it? I mean, in respect of those particular points, one could argue there's a preference, but there's clearly a bigger picture here.
Well, sure. Limiting yourself to those particular points, it's not that one could argue that it is preferable. It is preferable in respect of those two particular points, isn't it?
It depends on. It causes less harm.
Well, it causes no harm to ecological receptors, whereas the GCP scheme causes harm which is required to be mitigated. That's the evidence that is before the inquiry, and on that basis the CPPF alternative is preferable in terms of its effect on ecological receptors, is it not?
The problem yes it is, but the problem we have is that it's very difficult to look at it on that narrow basis, because part of my function at this inquiry is to consider the overall planning balance. And it's not just about those areas where your alternative scheme, if it were deliverable, might cause no harm and ours does.
Sure, but we've got to deal with things.
One has to look at it as a whole.
No one's suggesting that you don't, but we've got to look at these issues on a topic by. We've got to understand the things that feed into the overall planning balance, which is why I'm asking you the questions in the way that I am. But no one's suggesting to you, Mr. Sensical, that we don't look at the overall picture. Don't worry about that. In terms of BNG, we know that the applicant scheme is likely to require the delivery of net gain off-site, don't we?
We do.
And it's right, isn't it, that the CPPF alternative would similarly be able to deliver a net gain in biodiversity terms, whether as part of the scheme or by way of off-site improvements. That's right, isn't it?
Do you want to point me to some specific evidence on that? I'm not doubting you, but I'm just loath to just keep agreeing that's right, isn't it? When you're not pointing me to any evidence.
Well, I can take you to the evidence of Mr. Woodfield.
Yeah.
So if you want, Mr. Woodfield's, if you can take up Mr. Woodfield's proof.
Hang on a second.
You tell me when you're there.
I'm on the website. So, what's the CD number?
Oh,
Sorry,
that's a good question. Sorry,
2610W4.
2610W.
Thank you.
Yeah.
And then if you turn within the PDF to page 24, and says I'm going to give you the
PDF 24.
PDF 24 says that is section 4.4 on page 20, internal page numbering.
Yeah.
Are you going to section 4.4?
4.4, yeah. Sorry, Ms. Sensical,
I'm there.
You're there, sorry.
Apologies, I am.
4.4.2, we see in quantitative terms, this is the evidence, I'm going to dare to say unchallenged before the inquiry, that the CPPF scheme will result in a net loss of 5.96 area-based habitat units, right?
Mm-hmm.
Now, the applicant's scheme on its own evidence will involve a greater loss of habitat units than that. And obviously Mr. Woodfield's evidence is that the applicant has significantly underestimated the loss of habitat units. Now, if the applicant's position is that that net loss can be compensated for by way of the delivery of off-site units, then it must necessarily be the case that a net loss of 5.96 area-based habitat units can be, that the required gain can be delivered off-site, so far as necessary.
Yeah, thank you. I just don't like to keep agreeing with you when I haven't got the evidence in front of me.
Fine. So in BNG terms, you say that the GCP scheme delivers a benefit in BNG terms. That benefit is equally deliverable by way of the CPPF alternative. That's fair, isn't it?
On that basis.
Next topic then, heritage. So far as the section of the route that we're concerned with, the GCP scheme is identified to cause harm to the Coton Conservation Area, and that harm is identified to be at the lower end of less than substantial. That's the evidence given by Mr. Wilson. so far as the CPPF alternative is concerned, both Mr. Littlewood and Mr. Wilson agree that there would be some harm to the setting of the American cemetery.
Yeah.
Although there is a dispute as to whether both assets that comprise the cemetery would be harmed or whether it's just a registered park and garden. But I just, proceeding on the basis of your evidence as given by Mr. Wilson, to avoid the need to get into that dispute, his position was that the harm to those assets as a result of an alternative scheme which necessitated some use of the verge between the existing road and the hedge, he identified that harm as being less than substantial, and he used the words on the low side of less than substantial. So if we're in the categorization of...
Can we just make sure that this is put on the proper basis? Because Mr. Wilson gave evidence on the assumption that it could be confined within highway boundaries, and then he caveated that on the basis that if it couldn't be.
Yeah, well, I think my question was very clear. As a result of, I've written it down, an alternative scheme which necessitated some use of the verge, and he gave an answer on that basis, and I'm asking him about that evidence.
Because I recall asking him about that, and I think I was taken to his proof where there was a sort of a caveat. I can't remember the words. I wonder whether it is helpful just for everyone's benefit to look at Mr. Wilson's proof, because I think he said, I can't remember, I think he said there would be harm, but was the effect, but if it went into the...
Well, I think he gave oral evidence as to if the scheme necessitated removal of the hedge, what the level of the harm would be.
Yeah, no, I'm just referring to what was in his proof, just because I was taken to that.
Yes, I can't immediately, if someone has the reference.
6212, 6211 and 6212, Mr. Wilson, which is CD 2601 APP W23. So this assessment, so degree of less than substantial harm towards the lower end of the range, this assessment assumes a best case that any land takers are only on the southern side of Madingley Road and no land outside the highway boundary, which includes the verge, would be required.
Yeah.
So
well,
if land taken on the northern side of Madingley Road was required, the assessment would need to be reviewed.
Yeah.
And he gave some evidence on the effect on the RPG.
So in oral evidence, that's what I was quoting for in my question. He considered the position in respect of two situations, one in which there was some, as CPPF contend, there'll be incursion of the carriageway into the verge. And as I said, he gave evidence that the harm would be less than substantial and towards, I've got a note of it, but I'm going to read it out so I don't get it wrong. 2 seconds. And he said, and I am quoting from him, on the low side of less than substantial. He then also gave evidence in respect of what the position would be if there were incursion to the hedge. Now, I want to make, my question was clear, I'm not talking about any incursion into the hedge. We don't say any incursion into the hedge is necessary. I'm talking about the evidence that he gave that if there was an increase in the width of the carriageway towards the hedge, the harm would be less than substantial and on the low side of less than substantial. I think that's a fair summary of the evidence that he gave.
Yes, and we also have the evidence he gave this week when the inspector asked him about it, and I don't know whether you were
I'm not
here
familiar with that evidence.
No, and what he said, and I'll be corrected if I'm wrong, but I've got Mr. Henderson's note here. The inspector, he was giving evidence just in relation to Clare Hall and that area. We didn't lead any evidence on the American Military Cemetery. Mr. Underwood then asked him a question about the American Military Cemetery. I then re-examined on that, and I asked what are the likely consequences of a review, which is related to that passage in his evidence that I've just referred to, on the assumption that the roadworks were extended to the north. Would it be a higher or lower degree of impacts? Answer, higher if to the north. If land within the curtilage required, there will be an increase in the level of harm.
Well, so I'm
ju-
not sure that's necessarily inconsistent. I don't want to get bogged down. I've
Yeah.
got a clear note of what Mr. Wilson said. I'm just going to ask my question on the basis of the evidence that he gave at the session that I was attending at. So I'm not.
Yeah.
If you need to know what my question was, you can always have a look.
Unless you or anyone else has a concern, I've got a clear note of what he said, and I'm going to proceed on that basis.
But we can't, with respect though, we can't ignore the more recent evidence that Mr. Wilson, well, I can't ignore it because I heard it.
Well, let me ask you the question on the basis of the evidence that he gave in response to the questions when he was dealing. I'm not, Mr. Sensko, I'm not convinced that the record of the evidence given by Mr. Wilson is inconsistent with what he said anyway. If I have no problem with him saying that if there's an incursion to the north rather than the south, that's going to be more harmful. It doesn't undermine the evidence he gave earlier, which is that if you do incur the carriageway to the north, closer to the hedge, his clear evidence was less than substantial and on the low side of less than substantial. And I'm going to proceed on that basis, okay? So are you happy with that? I mean, I don't want to get bogged down in those points, but that was his evidence.
My question was along the lines of how Mr. Wilson had considered the effects of the road at Rifle Range Road in terms of the green strip that runs between the Erskine listed building, and I just asked him whether words to the effect of whether he considered that on the same basis that he considered the CPPF alternative. From my understanding, I was taken to that paragraph in Mr. Wilson's evidence, the 6.2.12, where he's made the difference between an effect where a notional scheme wouldn't extend beyond the current carriageway and would only go to the south, and a notional scheme where it would. And I must admit, from my recollection, I'm not looking at words, I don't think he really said anything different to that, other than he said it would be more harmful. So,
So in which case there's no issue whatsoever. We've got his.
Yes. Well, I've just reported our note of it. But can I suggest, so that we don't get bogged down on this, that Mr. Parker proceeds, he can put the basis of his question, assumption, he doesn't have to base it on a precise what Mr. Wilson said, but he could set out the assumption of the degree of harm and then ask Mr. Sensical the question. And then we don't get bogged down.
Well, that's fine, but I don't think we need to get bogged down. I think his evidence was clear.
Presumably, if he needs to, Mr. Sensical will caveat his reply in any event.
Yeah.
In any event, right, but that's fine. Well, Mr. Sensical, I want you to proceed on the assumption of the evidence that Mr. Wilson gave in the session when we were looking at this topic, and the evidence that he gave was that the harm would be less than substantial and on the low side of less than substantial. Are you clear about the assumption on which I'm asking you to answer the question?
Just remind me as to what the assumption was as to whether or not your proposal encroached onto the grassed area.
Yes.
In front of the.
Yes, it does.
It does.
It does. And his answers, less than substantial, on the low side of less than substantial, were dealing with that proposal. Yeah.
Right.
So on that assumption, yeah.
Okay.
Now, as we know, where there is less than substantial harm to the significance of a heritage asset, that harm must be weighed against public benefits. That's policy in the MPPF. Now, carrying out that heritage balance for the purpose of the MPPF, you have identified that the GCP scheme would obviously give rise to a number of benefits in planning terms. Those are clearly set out in your proof and your table, so on. Now, again, assuming that the CPPF alternative scheme is deliverable. Now, if on that assumption, if you were promoting that scheme on behalf of the council, you would agree, wouldn't you, that the public benefits associated with that scheme would outweigh the less than substantial harm at the lower end of the scale to the setting of the American cemetery, wouldn't you?
I'd have to consider the scheme as a whole, wouldn't I?
So you have to, the MPPF policy requires you to weigh the
This is
public
really-
benefit
yeah,
against the harm.
This really doesn't help. I'd have to consider the scheme as a whole. If it were right that it was at the lower end of less than substantial, and there were no other harms, yes, I mean that.
Well, for the purpose of the MPPF policy, you're required to weigh the heritage harm against the public benefit.
Yes.
So for that purpose of that policy, you're not weighing any other harms in the balance.
All right. I'm sorry, I'm really not clear as to what the question is anymore.
Okay. Do you want me to
Just ask me
take you to
again.
the relevant? Do you want me to take you to the relevant part of the MPPF?
We'll have one more go at this. Just quickly repeat the question, Mr.
Yeah,
Harper.
Ms. Sensible,
One more opportunity for Mr. Sensible to reply.
Ms. Sensible, you're aware that where there is less than substantial harm to the significance of a heritage asset, you are required by the MPPF to weigh the public benefits against that harm. Yes? So if you were required to carry out that exercise on the basis that there would be less than substantial harm at the lower end of the scale to the significance of the American cemetery, as was Mr. Wilson's position, the public benefits associated with the scheme would outweigh that harm, wouldn't they?
Strictly on that basis, yes.
So on that basis, or strictly on that basis, such harm as would be caused to the significance of the American cemetery would not be a reason, by reference to MPPF policy, to find that the CPPF alternative was not deliverable, would it?
On its own, no, that wouldn't. But there are other reasons, I think, why it's not deliverable around the American cemetery.
Moving on, again, I'm not. Those are matters subject of other evidence, Mr. Sensible. We're not going to get into them. That's fine. I've got your answer to my question. Carbon.
But you've also got my caveat.
Yes.
Yeah, which we understand. You've made it a number of times, and we've said we don't need to deal with it, but you keep. That's fine. Anyway, carbon. There's a dispute between us as to whether the scheme would give rise to a carbon benefit, as the applicant has claimed. You're aware of that dispute, yeah? Now, let us assume, for the purpose of my question, that the inspectors find, in accordance with the evidence given by Professor Hurst, that the scheme is a net emitter of carbon rather than giving rise to a net saving. Okay? You're happy with the assumption on which I'm asking you the question, yeah?
Understand the assumption, yes.
Now, that, in your view, is a matter which would necessarily weigh against the scheme, wouldn't it?
It would, yes.
Thank you. And on any view, well, there is agreed evidence before the inquiry that the CPPF alternative scheme would give rise to fewer carbon emissions. You're aware of that, I assume?
I'm aware of that argument, yes.
Well, no, you're aware that it is a matter of agreement between the parties that the CPPF alternative would give rise to fewer carbon emissions, yeah? You're aware of that?
Can I just ask whether that question is premised on the assumption, which I assume applies to the BNG as well, that there's been no assessment of a new bridge over the M11?
I think, well, no, it's not, because even on that assumption, the evidence before the inquiry is including that there would still be, that the CPPF alternative would give rise to fewer carbon emissions. I don't think there's still no dispute on that point.
I'm not sure there is any evidence on that.
Well, no, that it was, okay, well, fine. I don't want to spend time going back for our notes. Assume, for the purpose of my question, that the CPPF alternative would give rise to fewer carbon emissions, yeah? Assume that to be the case. You're happy that you understand that assumption?
On that assumption, yes, go on.
Yeah, so in that scenario, again, the CPPF alternative has fewer impacts in terms of its carbon effect, or conversely would have greater benefits in terms of the carbon savings, wouldn't it?
With all those caveats and assumptions, and as Mr. Cameron said, if we leave out the discussion around whether you need a new bridge or not, yes,
Yeah. Best and most versatile agricultural land, you have identified in your proof that there would be a significant residual effect in terms of the loss of BMV. Yeah.
Limited, not significant.
Okay. It's take up. It may be that I don't take up Mr. Lewis's proof, please. Paragraph 5. Sorry, hold on 2 seconds. I'm going to need to just find it. If you can turn, please, to... Are you working from a paper copy?
I am.
On
Yeah,
page 74.
Very old school, I'm afraid. Yeah.
Paragraph 5.14.4. Mr. Lewis expresses the view that the loss of BMVL introduces a significant residual effect.
That's what it says. Yeah, that's in an ES context, I would imagine he was speaking. I'm not sure, but
Okay. So,
well,
do you agree?
You asked me what my view was.
Well,
My view
I
as
didn't,
to
but
well,
okay.
my view as to the harm caused by that loss is set out in my table.
Okay. So do you agree that there would be a significant residual effect in terms of the loss of BMV as expressed by Mr. Lewis in his proof at 514.4, or do you disagree with that?
In the context that I think he's looking at this from an ES perspective, I would agree with it. But in terms of the planning balance, I stick with what I said in my table.
And Mr. Lewis there refers to the scheme incorporating multiple forms of mitigation. I mean, I'm not quite sure what he's referring to there, but
Well, neither am I.
Okay, fine. I mean, obviously the loss of BMVL cannot be mitigated. It's not proposed to create BMVL somewhere else to compensate or mitigate for the loss, is there?
No, hence I've come to my own conclusion as to the planning, where the planning balance lies.
Sure.
Regarding the loss of...
That's helpful. In terms of, in your note, you refer to the BMVL being of lower strategic value. Yeah? That's what you say in your note.
Where are you looking?
I see it on page 19.
Sorry, sir.
Page 19. Right at the end of the table.
Yeah, that...
Yeah. Well, should I ask my question?
Now,
the strategic value of BMVL is not a matter which is addressed by any policy which applies to BMVL, as far as I'm aware. Is that right?
Correct.
So your suggestion that one should, I think, reduce the weight to be accorded to the loss of BMVL by reference to its strategic value or otherwise, whatever that means, is not a judgment which has any basis in policy.
That's probably fair.
Thank you. And in terms of any loss of BMVL, obviously those losses, there's no loss of BMVL associated with the CPPF alternative. So in those terms, those strictly limited terms, according to that caveat, there's no impact, is there?
In those strict limited terms, that's correct.
Now I want to ask you one final question. And for the purpose of this question, I want you to assume, and I'm going to be very clear about the assumption on which the question is based, Mr. Sensical, because those matters have been the subject of evidence from others, Mr. Whitehouse, Mr. Lonergan, Mr. Lee, Mr. Johnson, we've had a lot of evidence at this inquiry. I'm not asking about any of that evidence. That the inspectors accept what has been put before the inspectors by CPPF, that the CPPF is deliverable within a similar timescale to the applicant scheme, that the CPPF alternative...
It's plainly not deliverable.
Well, okay, I haven't asked my question yet, Mr. Sensical. it's feasible and it's safe, and it would give rise to equivalent transport benefits to the applicant scheme. Now, you may have your own views about those matters, Mr. Sensical. I'm not asking you about that because that's been the subject of evidence from others, okay? My question is expressly premised on that assumption for the purpose of your evidence in respect of the planning balance, which is what you're here to give evidence about, okay? You understand the assumption on which I'm asking you to answer my question.
I understand it, but it's completely hypothetical.
It is hypothetical, yeah.
And I don't think it's of any benefit to this inquiry to
well, that's for me
answer
to
it.
Judge and the inspectors
not really.
to judge.
I think it's for me to judge too.
Okay, well, you've given your view that it's of no benefit. I say it is of benefit, and I'm going to ask you it. So on the assumption that I've set out, the inspectors would be driven to find that the CPPF alternative does provide an alternative way in which the applicant scheme could be delivered, which avoids the litany of harms that we've spent some time going through this morning, wouldn't it?
Sorry, is this the scheme that only has buses going in?
If you can just answer my question. My question is very clear. I set out the assumption. You said you understood the assumption, Mr. Sensical. If you can just answer the question.
I think he's entitled to clarify what's being put to him. And
Okay,
if you could clarify
Just remind Mr. Sensical of what the CPPF scheme is.
and the position on the hypothetical assumption on delay as well.
Well,
what's
I'm-
being put on delay.
Well, I'll remind you. I thought I asked you specifically whether you'd understood the assumption. You said yes, Mr. Sensical, but I'll ask you it again.
I caveated my answer, actually.
Okay, so let's be clear. So the assumption that I'm asking you to base your answer on for the purpose of this hypothetical question, because I'm aware that other witnesses take different views, and you may have different views. But let's assume that the CPPF is alternative. CPPF alternative is deliverable within a similar timescale to the applicant scheme. Yeah, you're happy with that?
But how
that
can we
assumption?
make that assumption?
Well, because that's because
that's clearly not possible.
but that's not your position. But that's CPPF's
Can you
case.
let Mr. Parker ask the question, and then you can answer, and then you can provide a caveat. That would be the most helpful way.
Sorry, sir.
So in terms of deliverability and delay, Mr. Sensical, there's a dispute between the parties, yeah? But we've had evidence on that, and we've had that dispute, and the inspectors will need to take a view. So what I'm interested in is your view on the planning balance in light of the dispute, okay? So that's why I'm asking you the question. So let's assume that the CPPF alternative is deliverable within a similar timescale to the applicant scheme, yeah? You're happy with that first assumption?
I get the assumption, yes.
Yeah. That the scheme is feasible and that it's safe, yeah?
Yeah.
And that it would give rise to equivalent transport benefits to the applicant scheme, yeah?
Equivalent transport benefits.
Yep.
Okay,
Yeah, you're happy with that assumption? You're happy you understand that assumption
So-
and the basis on which I'm asking you to ask the question?
Can I ask you a question based on that question?
It's unconventional, but let's try it. Go on.
It goes back to the point I raised earlier. Are we talking about a two-way scheme?
No, because the CPPF alternative is not a two-way scheme.
Thank you.
Mr. Lee has given evidence about that. Mr. Cameron had the opportunity to ask a question about that. He didn't. Mr. Whitehouse has given evidence. So, yes, assume that, for the purpose of my question, that an inbound busway would give rise to equivalent transport benefits to the applicant scheme and answer the question on that basis, okay?
So you're asking me to, sorry, another leap of faith here, that an inbound-only scheme has equivalent transport benefits?
Yes, I'm not interested in your views on that because the inspectors already have evidence in respect of those matters, which hasn't been challenged by Mr. Cameron. So yes, I'm asking you to make that assumption, and I've explained the reason why. Okay.
It wasn't a question about outbound, but there wasn't an acceptance of equivalent benefits.
Well, that's what Mr. Lee says expressly in his report, and no challenge was made to that evidence. So yes, it was. So that's why I'm asking the basis on that assumption. Okay.
Okay, carry on.
Yep, so that's the unchallenged evidence before the inquiry, and that's why I'm asking you the question on the basis that I'm asking you it on, okay? Do you understand that?
I do.
Yeah. So on that assumption, the inspectors would be driven to find that the CPPF alternative provides an alternative way in which the applicant scheme could be delivered, which avoids the litany of harms to which we all agree wouldn't arise with the CPPF scheme. That's correct, isn't it?
With all those assumptions in place, I find, as a professional, I find this really difficult, sirs. I really do, because there are so many hypotheticals in here that I...
Well, Mr. Sensical, you must answer the question in your own way.
Yeah, well, yeah.
And if you have reservations, you
I
must
have,
make those,
I have
you must make
serious
those clear.
reservations about asking the question, sir.
Well, I've asked you a
It's
question.
so
If you don't want to answer, that's fine. I can move on.
I don't
I've
want
asked
to
you.
answer it. I think it's so hypothetical. I do not want to. I do not want to.
Well,
answer it.
that was my final question, sir. I don't have any more questions for Mr. Sensical.
Fine. Thank you, Sensical.
Thank you.
Martin. Mr. Underwood and I have some questions, but I think we'll take the lunch adjournment now and come back to those. So, adjourn the inquiry and resume, please, at 25 to 2.